Circuit Court Division CRD in for Duval County in the state of Florida is now in session. General Judge Mark Morello presiding. Ensure all cell phones are completely powered off and are not visible. There will be no talking while court is in session. You may be seated. Good morning.
Both via Zoom, okay. See, we've still got that humming. Patrick, that's what I was doing yesterday. Which is
Yesterday. What did you do?
No, it's not letting me do it. All right, good. Thank you. Just gotta wait. We'll wait a couple minutes. Karen needed to run an errand. So when we're doing the Zoom, the attorneys, like normal, will talk from the podium.
Yes, sir. Remember that last time we had it, just like that, Judge? Yesterday with Larry. Sounds good and happy.
Okay, very good.
Not going to go that far away, right? You're not leaving.
I think he's staying. I think he's going to stay. We got all our jurors. You ready? Oh, you gotta do that. Yeah. You all set? Okay, let's go on the record. Show Mr. Tillis is present with his attorneys and the state here for the continuation of the penalty phase of our trial. I believe the defense had indicated they have 2 additional witnesses who are going to appear via Zoom this morning. They are, I think we have it set up. They're in our waiting room. Which one do you want to call first? Okay. So once the jury comes in, I'll admit Ms. Brinkley and then swear her in, and we'll be ready to proceed. Are we ready to bring the jury out?
Yes, Your Honor.
So much as we ask the court for a continuance.
Understood. All right, let's get them. And I believe you do need to conduct your examinations. Yes, ma'am, from the podium. Right. Thank you. You may be seated. And good morning, members of the jury. Welcome back. We are ready to continue with the testimony. The defense was in the middle of their presentation. And Ms. Miller, I believe the next 2 witnesses from the defense are going to testify via Zoom.
Yes, sir, that's correct.
Okay, go ahead.
Defense would call Shannon Brinkley.
And members of the jury, do you have are your monitors working? Do you see? Okay. Ms. Brinkley, this is Judge Borello. Can you hear me?
Yes.
Okay, very good. Can you raise your right hand, please? You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
If you can put your hand down. Ms. Miller, you may proceed.
Thank you, sir. Shannon, would you please tell us your name and spell your last name?
Shannon Brinkley, Brinkley.
Where are you this morning? What city?
Sacramento, California.
What is it that you do for a living in Sacramento, California?
I'm an elementary school teacher.
It is early there. It's about 6:20 in the morning.
Yeah.
Thank you for being with us this morning. Tell me how you know Russell Tillis.
I met Russell in 1981. We got together and we dated, and then I got pregnant when I was 17, and I moved in with him, and we lived together for a while. And then after a while, it wasn't working out, so I moved out, and I wished him well. We didn't have, I wouldn't say it was a terrible breakup or anything. It wasn't horrible. It just didn't work out.
My understanding is y'all met in an office building, waiting for appointments. Mr. Tillis was waiting to get his teeth fixed, Medi-Cal appointment.
Yes, so we were, that's how we met, was at the welfare office. He was trying to get on Medi-Cal to get an appointment to see a dentist, and I was in there for another reason. And we were waiting for a while, and I can't remember who approached who. Probably he approached me, but we were both, looking for somebody to talk to while we were waiting. And I think at the end of the appointment, I needed a ride, and he gave me a ride home. And that was the beginning of our relationship.
Mr. Tillis, Russell would have been about 20.
Yes, I was 17 when we first, I might have been 16, late 16 at that point, and he was 20, yeah. So he's 3.5 years older than I am.
I think you mentioned this. Do you have any children together?
Yeah, we have a child. His name is Nathan. He's my only child.
His name
Yep.
is Nathan Tillis.
Nathan Russell Tillis, named after his dad, partly.
And how old is Nathan?
Nathan was born in 82. He's going to be 39 this year, so he's 38 right now.
Tell the jurors a little bit more about your relationship with Russell. Good, bad?
So I was still in high school, and he wanted me to continue getting my high school education. He wanted me to graduate, and he didn't expect me to work, which was really nice because we needed the money. But he went to work every single day, and he totally provided for us. It wasn't perfect. We didn't get along all the time, but for the most part, it was fairly good. What happened is I started putting pressure on him to make more money, and at one point he decided to start selling drugs. And I didn't take drugs at that time, or really ever, but he started selling, I'm pretty sure it was methamphetamine. And my dad was over one day and saw it, and told me he saw Russell preparing it and saw it in person, and he told me about it because Russell didn't tell me. I didn't know. But then it became very obvious after a while that he was using it himself. And that's why, to make a long story short, that was the beginning of the end for me. Plus some things that I learned about him while we were together kind of scared me a little bit, and it made me not want to invest.
Did you know that Russell had a history of drug abuse when y'all got together?
I did. He told me his mom, that he was addicted to speed. I didn't know what it was exactly, but he told me that his mom had helped him get over it. And there's certain things in my mind that I remember clearly, and there's other things that I just remember vague memories of, but I remember he's telling me how much he appreciated his mother, and that it was really hard, that she practically had to tie him down or something. I don't know, somehow or another she kept him away from it. And he got off of it, and he wanted a fresh start. And I think he wanted to get away from some bad influences there in Florida, and he came out to California for a fresh start. And he met me, and I was, you know, kind of, I mean, not perfect or anything, but I was more on the wholesome side. And I think that it was good for a while. And for whatever reason, he decided not to, you know, stay with that. It was too hard, or I don't know why, but he went back on drugs, and it just became bad. At one point, I guess you could say the final straw was when women were knocking on our door late at night, offering, for what I felt like they were offering sex in exchange for drugs. And I was right there, and I like, this is not cool. I didn't like that at all.
Did Russell ever share with you anything about his relationship with his father?
Yes, he did. He mentioned to me right towards the beginning, soon after we moved in together, that his father was abusive to him. And of course that intrigued me. So he wasn't like really forthcoming, but I did pressure him and ask him like details, like, what do you mean, and how was that? And he basically told me that his father sexually abused first Claude, the third, I think his name is Bubba, and then it became him. And I don't know exactly how old he was, but it was definitely my impression that it started when he was pretty young. And I remember him saying that at one point it stopped, and then he said his brother started to do it too, and I think to him. And then I think that was like really hurtful, because before it was the both of them were the victims, and now his brother was doing it to him. But I don't know how long, or I don't know if that was just for a very short time. I don't think it was ongoing with the brother, but I think it was for a long time with the father.
You say you asked Russell details. Did you ask him any specific questions about the sexual abuse?
Yes, I did. I asked him, like, what did, I didn't know what it was, if it was just touching, or, there's a lot of different degrees. And I remember asking him, do you mean like all the way with the sexual, the anal penetration? And he nodded his head, but he did not want to talk about it. It was, too bad to talk about.
Did you ever try to confirm any of that information that Russell told you about his father with Russell's mother, Margie?
Yes, she came out for a visit. And by the way, she was a wonderful person. I really, really loved her. She came out, and after we, got to talking, I asked her why did she allow that to happen, that I felt like Russell was a little bit broken because of that. It kind of like messed with his head. And she said she didn't allow it. I think she told me that she didn't know what was going on at first. But then once she figured it out, then she put the boys in a trailer that was next to their trailer. I don't know if it was a house or a trailer, but she put the boys, she told them, move them into a trailer that was adjacent to their home, and told them to lock the doors at night and not to let their dad in. And I'm not sure when that happened. I thought maybe I remember him telling me he was around 12 when he moved into the trailer, but I don't remember exactly how old he was when Margie moved them into the trailer.
And just so we're clear, everybody's named Claude. Russell's father is Claude, Russell's brother is Claude, his brother's son is named Claude, correct?
Yeah, do you go Claude the first, Claude the second, Claude the third, or how do you guys do it?
Well, everybody is
That's,
Claude, so I just wanted to be clear when you talked about Russell's father,
The third, yes, correct. Yeah, they were both abused, for sure.
I want to change topics a little bit and talk about your son Nathan a little bit. What does Nathan do for a living?
He's a welder.
Why is he a welder?
Well, because when he was growing up, I used to talk about his dad. You know, he had questions, and he used to say, what does his dad do? And I would tell him that his dad was a welder, and that I thought that he would be a good welder someday, too. He wanted to be an accountant, and he went to college for a little while, because he's really good. Nathan's really good with numbers and money. But he kind of hit some of his career choices, so that when college didn't work out, he became a welder, and because I encouraged him to. And I thought it would be also I think welding is a nice job. It's not just a job, but it's also a chance to build things, make things, be creative. So I thought it might be something that suited him.
How old was Nathan when you left Russell?
He was only a few months old, maybe even just like a month and a half or two, something like that.
And did Russell ever attempt to try to get back with you?
Well, yeah, he did. I don't think I really left the right way. I didn't really give him any warning that I was leaving. So I think when he found out, he was probably, a little upset. And then he first found me. He came over to my new place, and we had words. He got angry at one point because I was going to call the police or something, and I remember he pulled the phone wire out of the wall, but that was about the worst of it. And then I moved to a new place, and he came to visit me before he went to Florida. I believe he called me first and asked me if it was okay if he came over. I remember him asking me first before he came over, and I thought that was cool. So he came over, and he made one more attempt. Do you want to try to make this work? Because I'm willing if you want to try to make this work. And I said, no, it's just too much. I can't do that right now. The reason is, it wasn't just the drugs. It was the fact that I was nervous about his past. I was nervous about the history that he had with his dad. And I was worried that, this doesn't even seem reasonable now, but I was worried for my son. I thought, I don't want my son to be raised in a household where it's okay to abuse children, or it's another story he told me was like his grandfather, Claude the First, I guess, used to pay them money to beat up black people because they thought it was funny. And so after they would do it, they would go see their grandpa, and he would pay them money because he was a racist. And it just seemed like, that they were raised by racists, or at least the grandfather for sure. And I never really saw Russell as a racist myself, but it just concerned me, that there was maybe those tendencies, and I didn't want to have anything to do with that.
So and to be clear, when Russell and Claude, his brother, were children, their grandfather would pay them money to attack black people.
Correct. So from what I understand, they would drive around. So this might have been when the boys were young teenagers, because I think Russell used to hang out with his brother, and a friend. There was a friend, I can't remember the friend's name, but they used to hang out a lot together, and I think Russell used to tag along with his brother, and they would find random black guys walking on the street alone, and they would, I think, get out of their car, beat them up a little bit or a lot of it, I don't know. But then they would go to the grandpa, and grandpa would give them money for it.
Claude, Russell's brother, is older than Russell, correct?
Yes.
A couple years older?
Yeah, I never met him, but yeah.
Has your son Nathan struggled with his own addiction issues?
Yes, he did. So at one point I talked to Russell, I don't remember when, but I started to have trouble with Nathan when he was around 12, smoking cigarettes. And then I got remarried to a man that had some kids who were having some issues themselves, their mother was a meth user. So to make a long story short, when Nathan was around 17, he started using meth. And it got really, really bad for a long time. He was on meth off and on for 17 years. And he got clean and sober about 4 years, 2 months ago. And he's been a completely different person. He used to be, he made his living by stealing. He was shoplifting. He did a few crimes, but a lot of really bad paranoia, like to the point where I didn't know if my son was still in there or not, because I would visit him and I didn't even recognize who he was. So when he did get clean and sober and he turned out to be okay in the head, I thought, thank God, because I was really worried that there was going to be some lingering effects. But he seems okay. Seems really good, actually.
He and Nathan, as you mentioned, also struggled with the law, did some time in jail and prison, correct?
Yeah.
Because of the drug use.
Yes, it's all about the drug use. It's about stealing and getting, and then also you get agitated on meth. You get all worked up, and you don't, there's a lot of things about meth. It's really bad. It's really prevalent out here in California. But yeah, you think you can get away with stuff, and you get really paranoid and just really freaky.
I think you mentioned this. One of Nathan's step-siblings actually was an older step-sibling that introduced him to drugs when he was about 12, yeah?
Yeah, I don't think he started using meth at 12, but yeah, his older sibling definitely contributed to that line of, heading down that road.
Nathan never had any kind of traumatic incidents when he was a child, correct?
Not that I know of. I don't think so. No. You can ask him that, of course, but it's probably up to interpretation. I think me getting divorced and remarried sure didn't help him out.
When he was 17, 18 years old, things got so off the rails with Nathan that you sent him to spend some time with Russell's parents in Jacksonville, correct?
Yeah, I had always protected him, from Russell's side of the family. And then at some point I realized, well, maybe that wasn't the wisest decision. Maybe I should have, trusted them more because Nathan definitely had gone down the wrong path and it was out of control and I couldn't do anything about it. So at that point, I'm like, what have I got to lose? Let's send him to his dad and maybe, something good will happen. And he visited his dad. And before he left, I just told him about Claude the second, the father. And I said, just make sure that you don't do anything. I don't know if I told him details, like I told you just now, because, it's private and stuff. But I just said, that he was abused in general terms and not to be tricked or let anything like that happen to him.
Nathan was with his paternal grandparents for maybe 3 months?
I'm sorry, I don't remember that. I don't recall how long he was there for.
Did Nathan share with you anything unusual or odd that happened with his grandfather when he was staying with them?
Nathan's a pretty tolerant person, so when he complains, it's usually founded, and because he usually doesn't say anything bad about anybody, even when he was younger. He's always just been really cool like that. But the only thing I really remember him saying was that at one point he was sitting on the couch watching TV, and he had his hand resting, or, you know, kind of like holding himself. He said he wasn't masturbating or anything like that. He just kind of had his hand there, and he looked up and he saw Russell's dad peering through the window or the doorway or something like that, looking at him kind of in a way that made him feel uncomfortable. Oh yeah, that he actually mentioned it to me, yeah.
And has Nathan spoken to Russell throughout the years when Nathan was a child?
No, Russell was in prison a lot when Nathan was growing up. There was a time in between prison where somehow or another I talked to Russell on the phone. I don't know how. He must have called us. I don't remember calling him, but I think I was kind of curious if he was going to straighten up and maybe be able to send us some money or something, because we were struggling. But he was nice to us on the phone, and I said, you know, are you going to... He never got involved, let's just put it that way. He was always... when he visited me when Nathan was around 2, just before he moved back to Florida, and I didn't want to get back together with him, he said, well, I'm going back to Florida, and, you know, basically this chapter of his life was going to be closed. And he kind of let me know right then that he wasn't going to, if he couldn't be a part of it, then he didn't want any, if he couldn't be like a major part or a playing part, then he didn't want any part. So pretty much he never had anything to do with Nathan.
One or two times throughout Nathan's childhood that he spoke with Russell on the phone. Is that fair?
Hold on a second. I can't hear her very well with that's going on. Can you repeat it? I'm sorry.
There were maybe one or two times that Russell spoke to Nathan on the phone in the course of having conversations with you throughout Nathan's childhood.
Yeah, that sounds right. That's correct.
Have you had the opportunity throughout the course of this trial to see Russell, or hear Russell talk on the news or anything like that?
I was watching news clips, and for the first time yesterday, I watched a little bit of the trial, but I didn't, I wanted to watch his testimony, but I didn't finish it, so I apologize for that. But no, I haven't been keeping up on it that much.
I understand. What is your opinion about Russell, who you're seeing now? Is he better, worse, the same than when you knew Russell Tillis?
Well, when I met him, he was clean and sober at the beginning, and he was a completely different person. And when things started to go south, I got out of there pretty fast. So he's not at all like, 14 felonies or whatever. Looks like he made a lot of bad choices along the way. So I would say he's definitely worse. And especially if he's still using meth after all these years. Most people, I would hope, will wise up and stop using meth, because it's very destructive and it destroys your life.
We had a conversation before this, obviously. Recall speaking with me?
Yes, once, yes.
You described Russell as like 10 times worse as you saw him now than when you knew him.
Yes, yeah. When I knew him, he was only 20, 21 years old, and he was, there was a lot of good qualities that I saw in him. I had a lot of hope for him, and it's just very disappointing to see, that he's spent so much time on drugs and making bad choices and a life of crime, basically. It's heartbreaking.
Can I have just one moment, sir? Yes, ma'am.
Brinkley.
Good morning.
My name's Alan Mizrahi. I'm just cleaning the podium right now. Just give me a second. It's okay. Not a big deal. Ms. Brinkley, I just have a couple questions for you. I want to clarify that your recollection is that you were 16 and Mr. Tillis was 20 when you first met, correct?
Yes, I believe it was shortly before my 17th birthday, so I think we met around August, and my birthday's in October, so, but I don't think we started having sex until I was 17, if that makes any difference, yeah. But it wasn't, he never pressured me or anything like that. I was already experienced there, so.
Were you still in high school? So you were in your, I guess, the summer before your senior year when you first met? Is that true?
Yes. Mm-hmm.
So did you graduate?
Yes, I did. 6 months pregnant, and he was at my graduation ceremony, and it was a good day. It was a very good day.
So it's fair to say that Mr. Tillis knew from the very beginning that you were a senior in high school.
Yes.
And shortly after you gave birth, that's when your relationship ended.
Yes.
So you knew Russell Tillis, the defendant in this case, for basically a year. Is that fair?
I lived with him, yeah, but I knew him more. I knew him longer, but yeah, I would say that the relationship was good for about a year.
And I want to talk a little bit about that because you indicated that you did know that Mr. Tillis was involved with drugs before you met him, correct?
Yes.
But because he was clean when you met him, he was, in your estimation, a completely normal person, correct?
I wouldn't say completely normal. Based on his past history, some of the things he said and did worried me.
Sure, I understand.
Yeah.
Let's put it this way. He was able to have a job, correct?
Yes.
And he was able to show you enough that you were willing to live with him and have a child with him.
Yes. We talked about getting married, stuff like that.
So at that point in his life, his brain wasn't scrambled or fried or anything like that, correct?
No, I don't know. He didn't seem like it was fried or whatever you said.
And during your short time with Mr. Tillis, did he develop a reputation of being a liar to you? Like, would you catch him in lies repeatedly?
He struck me as the kind of person who, he liked to tell stories about times that he got away with stuff. He seemed to get a little bit of a thrill from getting away with stuff, like outsmarting people. And I remember him telling stories, to that effect. And I was like, I always wondered why, that was so important to him. But I don't think he lied to me. There was some times where he lied to me. There were some things that he wanted me to do. And there was some retaliation stuff. At the time, I didn't like it, but he was never violent to me. I could give some examples of some things that he said and did, if that's what you're looking for.
No, ma'am. I was just asking if during the course of your relation, there's no reason to talk about all of it, but I wanted to find out if during the period of time you saw him, lie, manipulate things during your time with him. And you answered the question.
Yeah, some. Obviously, it didn't work out between us, so yeah. I think if he had been completely honest, perhaps, maybe we could have done better.
And you, it sounds, I want to get too deep into it, but it sounds like you had a family in, I guess, Sacramento at the time. Was it Sacramento?
Yes.
So you had parents and you had a structure that could support both you and potentially Mr. Tillis, correct?
Yes.
And they supported you
Yeah, I was a single mom. I made a lot of mistakes as a young single mom. I wasn't into drugs or alcohol, but love is not enough. Experience is really useful when you're a parent to have a little background.
And did you ever share the Russell Tillis abuse stories with your family?
No, I don't. I know I tell my mom a lot of things, but I don't talk about Russell's abuse because it's private. And yeah, I don't talk about it very much. I probably told my mom. Yeah.
Maybe you did, maybe you didn't. Is that fair?
I'm pretty sure I must have told my mom. I tell my mom everything. So yeah, I'm sure I must have.
Was there ever?
Yes.
I'm sorry to interrupt you.
No, it's my fault.
Was there ever a discussion about reporting any of this to the authorities?
Was there ever a discussion about
Reporting the crime.
hold on a second. I'm having some reporting. Can you say it one more time? Hold on a second. Or can you please not come in here right now? I can't hear him. All right.
My question was there ever a discussion?
I'm at home and someone's in the kitchen next to me getting ready for work, so it's just, maybe one more time, I'm sorry.
Was there ever any discussion about reporting the crime that Mr. Tillis disclosed to you?
Reporting the crime? Which crime?
What he disclosed about his father and his brother.
Oh, that, no. I figured that was his business. We never wanted to do that. He never wanted to report it. I think he wanted to forget it.
And even still, knowing that, you sent your 17-year-old son to live with these people that you knew or thought maybe had done these things to your ex-boyfriend.
Well, he wasn't gonna, I figured he's 17, he had a good head on his shoulders, and he had warning, and I knew Margie was gonna be there. So I felt like it was worth the risk. Like I said, at the time I sent him, he was pretty much out of control, and I needed some help. So yes, I was willing to take the risk.
My final question is, during the time that you knew Mr. Tillis, did he know the difference between right and wrong?
Did he know the difference?
Yes, ma'am.
That's a tough one because we had a lot of differences of opinion on what was right and wrong, and I thought a lot more things were wrong than he did. So I would say that he knew the difference. He just had his line of right and wrong was further down the road than mine was.
Thank you. That's all the questions I have.
Okay, thank you.
All right, Ms. Brinkley, thank you very much for participating, and I'm going to terminate your Zoom connection.
Thank you, bye.
Hi.
Phyllis, this is Judge Morello. Can you hear me?
Yes,
All right, raise your right hand, sir. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, sir. You can put your hand down.
Just need one moment. I apologize for having internet connection.
My name is Nathan Tillers. I'm 38 years old. I live in Vancouver, Washington.
Sorry. Who is your mom?
My mom is Shannon Brinkley.
And who is your father?
My father, Russell Tillers.
What is it that you do for a living, sir?
I work in a metal fabrication shop, welder and fitter.
Why did you go into welding?
I just had the opportunity, and I was good at it, so I just went with it.
Did you know your father was a welder?
Yeah, yes, I did.
Growing up, was Russell Tillis ever a part of your life?
Not really.
Did you and he ever speak when you were growing up?
Yeah, we spoke a couple times.
Tell me about, let's start with the first one. How old were you?
I was about 12 years old.
And what were the circumstances of that phone call?
He called my mother, and they talked for some time. She put me on the phone, and then we talked for quite some time.
And what did you and Russell talk about?
Well, we talked about just everyday stuff. We talked about the law. He was in trouble, and he was adamant that he didn't want me in trouble with the law, like, and make the same mistakes that he did.
He was trying to encourage you to not follow in his footsteps?
That's right.
Anything else you remember from that call with your dad when you were 12?
That's about it.
And when was the next time you spoke with Russell?
Next time I spoke with him, I was 18 years old.
And what were the circumstances of that conversation? How did that come to be?
Well, at the time I was in Jacksonville. I was staying with his parents, and I was at the time I was with his brother, and they had him on the phone, and I had the opportunity to talk to him again. And we spoke briefly. He wanted me to stay in Jacksonville. He wanted me to move up there permanently, and so we could have a relationship there.
This was during the, well, tell me first, how long did you stay with your paternal grandparents in Jacksonville?
3 months.
Okay. And you were 18?
Yes.
And Russell was in jail when you had this conversation, or prison?
Yes.
So you're spending time with his parents and his brother, and they facilitated you speaking to him.
Right.
In that conversation, Russell asked you to relocate to Jacksonville, is that correct?
Yes.
And did you consider it?
Yeah, I thought it sounded great. He offered to give me his truck so I could have something to drive around. I had a place to stay at his parents, and at the time I was there, I was working for his brother, so I had a job, I had a place, but I had a truck. That's more than I had at the time on the West Coast. But I ultimately didn't want to leave my friends and family, so, but it was very tempting offer.
Did anything unusual happen with your grandfather, Claude, when you were in Jacksonville staying with them?
Yeah, well, there was one incident that was kind of strange. That made me uncomfortable. I was in the living room watching a movie, and I noticed that he was kind of sneakily watching me through a window, trying to kind of like hiding. And I noticed that, and yeah, I thought that was very odd, and so I went out there and I talked to him. I didn't confront him about that, but I went outside and continued to talk to him about his business and what he does for work, and we talked a lot about our family.
You wanted to put an end to the situation where you were there watching the movie being watched by your grandfather.
Yeah, I didn't want to be in that situation.
I want to talk a little bit about your journey and what brought you to Jacksonville when you were 18 years old. When did you first start using drugs and alcohol?
I started using drugs and alcohol very young. I started drinking when I was about 7 years old, and really picked up when I was about 12. I started smoking marijuana and drinking on a regular basis. And then it just progressed from there. At 14, I started using meth, and ended up using that for about 20 years.
Let's talk about the first time you drank alcohol when you were 7. What were the circumstances of how that happened?
My mother was married, and my stepbrother was quite a bit older, and I took one of his beers and drank that.
That brother was like 19 at the time?
He was 12 years older than me, so he was about 19, I think.
How about when you then progressed to marijuana? Do you remember the circumstances of how that happened?
Yeah, I was at a friend's house, somebody I went to school with, and I was there for a couple nights, staying there over the weekend, and ended up, the majority of his family was smoking marijuana in the house, so I joined in on that.
How old do you think you were then?
About 12 years old.
And how do we get to the methamphetamine when you're 14?
That, again, was from my step-sibling, another stepbrother from my mom's second marriage. He had been using, and he had brought some home with him.
You said you used methamphetamine from about 14 to 34, roughly.
Right.
I think you probably started getting in trouble with your mom first, then the law. Fair to say?
Yes.
Your mom tough?
Yeah, she's very strong woman, very strong mind, strong will. She also at the time was very strict Jehovah's Witness, so there was a lot of rules in place that I didn't really agree with.
Was she a Jehovah's Witness because of the man she was married to at the time?
She became one before that. She met him in the church.
She is no longer a practicing Jehovah's Witness, is that correct?
That's correct.
At some point, does it progress beyond getting in trouble with mom to getting in trouble with the law?
Yes, it does. I got my first felony when I was 13, burglary, and from there I was on probation. Then they started drug testing me when that happened. They just kept me on probation. They kept extending it, and so then I was on probation until I was an adult, and basically.
So as a condition of your probation, you had to get drug tested, right?
Right.
Fair to say you were failing those drug tests.
Yeah, I failed them all.
And that's considered a violation of your probation.
That's right.
So then you kept getting more probation or more consequences for not successfully completing probation.
Right. Yes.
Do you get in trouble as an adult as well?
Yes, I did.
What was that?
I did.
Say again, sorry.
I have 3 more felonies as an adult. I have another burglary and then an assault and arson.
Tell us about the arson. What were the circumstances of that?
It's pretty embarrassing. I was just doing math in the bathroom and I had burned some garbage in the sink and I damaged the sink and part of the wall.
So that was the arson, was burning the garbage that caused the damage then to the bathroom.
Yes.
Did you go to prison as an adult?
Yes, I did. I did 2 years prison for the assault.
Tell us about how you got clean.
Well, I was just, my life was going downhill and I ended up homeless for years and I couldn't stay out of jail. So something had to change. So I moved up north to Washington State with my grandmother. And I went into treatment, this time of my own free will.
I don't think I asked you this at the very beginning. Are you currently in Vancouver, Washington?
Yes.
You guys are about 3 hours ahead of us, 7:10 over there.
Yes.
The treatment program, did you have to work steps?
Well, not in rehab. I did the rehab and then I did inpatient and outpatient. And then after that, I got into a 12-step program.
Is it still something you work on? Your sobriety?
Yeah, basically daily.
Was one of the steps forgiving yourself?
One of the steps is making amends for the people we harmed, and I am number 1 on that list.
Do you want to have some sort of relationship as an adult with your father, Russell Tillis?
Yes, I would like. Yes, I would like to.
You obviously know we're in court in Jacksonville and he's going to spend the rest of his life in prison, correct?
Yeah, I've been reading about it online a little bit.
Since learning about this process, have you done anything or tried to reach out to Russell?
Yeah, I sent a text message to one of his advocates and sent him some pictures to look at, and I wrote him a letter last weekend.
May I have just a moment, Your Honor?
Yes, ma'am.
1 second, Nathan.
Okay, Mr. Mizrahi?
Morning, Mr. Tillis.
Okay.
My name is Alan Mizrahi. I'm an assistant state attorney and I have a few questions for you. It won't take long, okay?
Okay.
Become aware that you were growing up without your father.
I'm sorry, what's that?
When did you first become aware that you were growing up without your father?
I can hardly understand. When I first became aware,
That you were growing up without your father.
Oh, probably around 5 or 6 years old. Yeah.
That's what I guessed. I just wanted you to give the answer. And would you agree with me that growing up with an absent father was traumatic for your childhood development?
I don't know if traumatic is the word I would use. It was, I felt like it put me at a disadvantage. I saw other children with their fathers, and all I had was my mother at the time.
In going through your rehab and the STEPS program, do you recognize that that played a role in what happened to you?
Yes, yes, I do. A lot of addicts and alcoholics, they have childhood trauma and events in their childhood.
Have you had the chance to meet your brothers and sisters, or at least half brothers and sisters?
No, I have not.
Do you even know their names or where they live or who they are?
No, I don't.
So you weren't aware that you had brothers and sisters that even live here in Jacksonville. You didn't know that.
I knew that I had a brother and sister, but I don't really know anything about them.
That's all the questions I had, Your Honor.
Okay. Ms. Miller, any follow-up? All right, Mr. Tillis, thank you very much for participating, and I'm now going to terminate the Zoom connection. Thank you, sir. Okay, can I terminate the Zoom connection? Ms. Miller, Mr. Maris? Okay, thank you. Members of the jury have a couple matters to take up outside your presence. The next thing that will happen is the attorneys will make their closing arguments to you. We should be able to do that this morning. I'll tell you the anticipated schedule, and then I would send you to lunch. You would come back. I'll instruct you on the law, and then you'll retire to deliberate your decision. Until that time, of course, do not discuss the case or look up anything about it. This recess should not be very long. We'll see you back in about 10 minutes. Okay. Any motions from the defense?
All prior motions, judgment of acquittal, and rely on prior argument.
Okay. Anything else from the state?
I will say that I've never heard about directed verdicts in criminal cases. I'll just say that.
The state has to prove the sufficiency of the evidence to support the aggravator.
I'm always learn.
Out of an abundance of caution, I'm proceeding as if that is a appropriate and proper step. So,
I rely on the evidence.
right, and the court will abide by previous rulings in the case and find that the evidence submitted is sufficient for the case to go to the jury during this penalty phase portion, and that the state has presented sufficient evidence for the aggravators that they are asking for to be submitted to the jury.
We have the
Yeah.
jury instructions on the screens for everyone to see. We'll also make changes. As of now, I think everything's good.
Do you have a hard copy that you've already
I
done?
have a hard copy there, changes if you will, obviously.
let's go back through them. We basically did our, for the most part, we did our charge conference yesterday. And remind me, only two closing, state and then defense, and that's it.
Yes, sir.
Okay, let's Ms. Wilson, you got the control there. We'll kind of, let's just do it this way. Let's slowly scroll down. Ms. Miller, Mr. Mayor, you just, and I'll do the same thing. Let's just stop if any of us have any concerns. Let's stop for a second. Okay. Stop. Okay. Go ahead. Okay. Okay. Go ahead. Keep going. Okay. Okay. All right, let's stop
And just, Your Honor, just for the court order of defense, I highlighted the ones that we had discussed yesterday as either needed editing or potentially were coming out. At least I think I got them all, but that's why there's some that are highlighted.
okay.
I'm not taking any out, the numbering stayed the same.
All right.
I just emailed you, we did edit the ad.
Okay, edit that, okay, yeah. All right, defense is fine with the first five.
We actually changed the first one, and I removed Howard and Clear in the slide.
All right, so number one should read, as a child, Russell David Tillis watched his father beat his mother repeatedly, period.
I thought that was consistent with what the court had ordered yesterday.
Right, because I assumed the defense would agree there wasn't any evidence about the coward.
I agree.
Okay, so just, that'll be a period after repeatedly.
Do you not have editing?
Yeah, let's go ahead and do that now, so we can see what the final version looks like.
With all cameras, the list is now up to 61, so we took out the ones before we started us to.
Let's get it off the screen for now.
Okay.
Yes, so much editing needed.
Yeah, however the quickest way is to do this.
And let's get the email that she sent and paste in the email to the, because the email doesn't go to the thing, to the card.
What are we doing? What are we doing here?
list. Pasting it over the old list. It's gonna take too long, we can't edit from there. We don't know which way. 67 instead of 47, it's 61. 61 instead of 47.
All right, well, can't we just go through the original list and then just go through the ones that were added?
The original list is all changed. He's doing it. Give us a minute, and it'll go much faster, Judge, I promise you.
All right.
I'm just gonna take it back up there. So
How long do you anticipate this will closing? How long?
30 minutes.
Mr. Hurd, go ahead and tell the jury it's going to be a little bit longer than we thought, that for their purposes we'll be in recess until 10:45.
no, it's already corrected, Your Honor. We're in a much better position.
Okay, so let's go back through these. Does the state, just tell me as we go through these if the state has any problems with any of these. 1, 2, 3, 4, 5, 6, 7, 8, 9. There was an issue, the state had raised an issue about belts, but I think you withdrew your objection, right?
Yes, with 9's fine.
That's fine, okay. 10. Yeah, that one's a little different. Let me read that one.
10's okay with the state.
Yeah, okay, that's fine. 11. Okay, that's fine. 12. 13. 14. 15. 16, 17, 18. 19, 20, 21.
I don't
I
know.
think I asked you this yesterday. Do we have 22? Did that to 20?
The one,
We're at 21 now. I agree. I don't think that there's any evidence
we agreed to take out 21.
of
All
21.
right, take out 21.
And then the testimony from Dr. Toomer was that Russell had cared for his mother when she was ill at the end of life and had his father. I think I evicted was here, but he said removed from the home or something.
Yeah, I just don't recall that specifically, but I'm okay with it. So stay, right, so 21's good.
I'm okay with it.
22's okay. 23, 24, 25. Hold on, 26. Okay. 27, 28, 29.
Hold on to 28.
Yes.
I would object to the last line.
I'm sorry, you would object?
I would object to the last phrase after the comma.
Well, there was one of those.
The DR between 1995 and 2004, he had one.
Yeah, you had one for fighting, so.
So that's why we're since 2004.
Yeah, all right. So 28's fine. State, you can obviously argue.
Well, my objection is not that. My objection is he wasn't caught. I mean, like, that doesn't mean that he wasn't violent in custody for over 20 years. It means he did not receive a DR for violence in over 17 years.
Well, we could put it as,
Well, in the standard is, has these been established by the greater of the evidence, which again is not the statute, but it is in the instruction.
How about if it just says, meaning he has not been accused of any violence in custody over 17 years? All right, so you got that, Ms. Olson?
I think they are accused
Meaning
of-
he has not been accused of any violence in custody in over 17 years. All right, that's good. 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, wait, 39. All right, 40, 41, 42, 43, 44. What do we have on 44?
That's about those.
That was Dr. Tumor's testimony. So most of the 44 on is based on testimony.
Tumor, Dr. Tumor. All right, 44 is 44 is fine. 45 is fine. 46 fine. 47. 48, 49, 50, 51, 52, 53, 54, 55. Yes, some of these are a little repetitive, but I think that's fine. 56, 57. Well, 58, let me see that.
Yeah, I object to 58.
That came in very, talking about this before, she's very good, maybe graph or something.
Well, I think that calls for a legal conclusion, though.
And I think I objected and it was sustained.
And his testimony after the objection was, there was a necessity for radiological study.
I mean, he said the thing that was objected to. I strongly object to 58, Your Honor. That's completely unfair.
I do not believe 58 as written is appropriate. I'm just trying to think if there's a way to place a mitigating factor based on the testimony. First of all, I don't think Dr. Tumor was qualified to make that comment.
That was Dr. Hopkins at the end, right? That testified.
He definitely not qualified to make that. He's a pharmacologist, toxicologist, so that's not, I think he's not qualified to say that.
Speculate on things not before.
Yeah, you gotta take out 58. I know it's over your objection, but take it out.
Go 58.
Then becomes that one. 59. I think that's that came out in testimony. Okay.
Did you take out human being? Did you take out human being?
No, that's not.
That's in there. Okay.
That's it there. All right, let's keep going.
What sort of light?
Keep going. And the rest should be relatively standard. Okay, let's go 125. Keep going. 6, 7, 8, 9.
You can take out the law enforcement.
So I think that's still needed.
Oh, for the guilt.
Yeah, because that's from the guilt phase.
You're right.
Okay, so we'll leave in the, you go ahead, we're good. Leave in the accomplice testimony, defendants become a witness. Okay, standard. Go ahead. All right. Go ahead. Then our verdict form. Okay. Okay. And I'll be telling them each of those must be, if they're gonna check yes, it has to be unanimous. Okay. All right. Sufficiency, yes. All right. Mitigating circumstances.
Your Honor, I think I added the line, you could see there, jurors should put the number of yes votes and the number of no votes under each mitigating circumstance. What we had before was just a yes, no, and it implied that the mitigating circumstances were supposed to be unanimous, which they are not. So I think that line tells the jury that it's just supposed to be a vote between them.
I think that's an excellent suggestion.
That makes sense?
And then Your Honor, the rest of the.
Hold on, you got a misspelling there on Russell, little thing, but you got, no, not there, below it.
Below this one?
Yeah.
These will have to be changed anyway, Your Honor, which I will work on, since these are the new.
Yeah, you gotta change the mitigating
Yes,
circumstances to reflect what we just did.
And that's what these will all reflect then, once I do that.
Yeah, fix that L there, add another L. Okay, you're good.
But then these
Yeah,
are
fix all those, yeah, there's no need to go through these again, just have them comport with what we just.
Yes, Your
voted
Honor.
on. All right, so let's keep going, go all the way past the mitigation. I think we ended up with 59 or something. All right, right, that's fine. Okay. All right. Okay. All right, then they gotta tell us if it's life, what the vote is. Okay? All right, so make, defense, do you want a hard copy to follow along with?
Please.
All right, so make at least 2 copies. One is gonna be the copy that I'm gonna read to the jury. They'll have it on the monitors and follow along, and that hard copy will go back to the jury. Make sure the defense has one, and then have everybody one. It's fine. They may want a couple extra copies, as you may recall from their guilt phase deliberations, they asked for another copy or 2.
Yep.
Okay, anything else we need to talk about as far as the charge conference?
Now, we renew all our previous requested instructions and objections to standard instructions.
Understood. We will be in recess then until 10:45, and we will start our closing arguments.
as it should be. We're almost at the end.
Did you guys get down to 59?
Well, if you call the mitigators.
5, and then 59,
Some of them are duplicative. It's all basically, he drank as a kid and did drugs. It's almost too gross for that.
Yeah, it's pretty bad.
It's almost over.
Mr. Alexander.
You guys had talked about doing instructions and then argument later.
They should be able to law. There's a reason why they've been doing that all these years. We can argue anything we want, but when you hear the truth, judge.
instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding this case. Each side will have equal time during this portion. There will only be 2 closing arguments. The state will go first, and then the defense will deliver their closing argument. First from the state, Mr. Mizrahi.
And may it please the court.
Yes, sir.
Counsel? The defendant knows the difference between right and wrong. But his line is a little further down the road. That quote that we heard just minutes ago perfectly encapsulates the character of this defendant. This defendant knows the difference between right and wrong. He just doesn't care. Because the only thing that matters to this defendant is himself. And that's why we're here, ladies and gentlemen. We are here because this defendant committed an aggravated murder. A murder that's so aggravating that it will outweigh any mitigation that you may consider is mitigation. The first, and frankly what the state contends is the most powerful of all the aggravating factors, is that this was not just a bad day or a bad week or a bad month for this defendant. It's a bad life. A life that in 1989 he kidnapped and tried to rape Maria Leone. He was convicted of that kidnapping. And just in case you don't think that that's too far removed from where we are today, in 2006 he repeatedly raped a 14-year-old and was convicted of child abuse. The law contemplates these prior violent felonies as aggravation because your decision here today about the punishment must take into account the totality of this defendant's life. The totality of the harm that he's caused. The totality of this defendant's harm is not to those poor women that testified yesterday, but are directly related to this crime. The second aggravator, you have, and by the way, the first aggravating factor about his prior violent felony, we have submitted the judgment and sentences from that particular crime, where he was convicted. Ladies and gentlemen, you will also hear that both child abuse and kidnapping, which is obvious, are crimes of violence. So this aggravating factor should be immediately checked off as having been proven beyond and to the exclusion of every reasonable doubt. And I submit that this aggravating factor by itself is enough to recommend and vote for a death sentence. But you've already also convicted the defendant beyond and to the exclusion of every reasonable doubt of felony first-degree murder. And this is the second aggravating factor, that during the course of this first-degree murder, the victim, Joni Gunter, was the victim of a substantial harm independent of the murder. And that was, she was confined forcibly against her will to help the defendant facilitate the felony, and or to inflict bodily harm and terrorize the victim. And you have already found that beyond a reasonable doubt. So again, at this point, we have two aggravating factors that have been proven beyond and to the exclusion of every reasonable doubt. And together they combine for even more weighty aggravation in this case, and even more evidence that you should vote for death. But you'll hear about three more aggravating factors, and these aggravating factors, the evidence in them was introduced during the guilt phase of the trial. And during the guilt phase of the trial, the dominant motive for this murder was for the purpose of avoiding or preventing a lawful arrest. It's not an escape from custody. It was for the purpose of avoiding or preventing a lawful arrest. Page 19 of the transcript. Something's gonna happen, and this is from Claude, this is the defendant speaking of his brother. Something's gonna happen if that bitch was to say my name. Then he starts getting scared. Later, the defendant indicates that the dominant motive for this crime is because his brother was recognized by Joni Gunter, and his brother wanted to make sure that he would not get in trouble. The only way to get away with the crime was to eliminate the witness. And you can also use the evidence from the prior crimes in 1989 and in 2006. What were the fatal flaws that allowed the defendant to be convicted in those crimes? Maria Leone and Brescia Settle identified him, were witnesses against him, and identified him that allowed him to be arrested. So the defendant was not going to let that happen again. This aggravating factor, the motive behind doing this, is not for some altruistic reason or even some morally justified reason. The reason for this killing is so he and his brother could get away with it. The fourth aggravating factor that you will hear is especially heinous, atrocious, and cruel. The law defines this heinous as extremely wicked and shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Joni Gunter. Now, the defendant's demeanor in The Wire shows the enjoyment that he took in doing this. But the primary evidence, even in The Wire, I think the defendant says something to the effect, and I'll turn to the page and give it to you specifically. On page 30 of the transcript, she knows I picked the bitch up and I got a soundproof room and she knows what's going on. Sammy Evans says, she know what time it is? Russell Tillis says, yeah. And he's referring to her kidnapping and then impending death. The victim knew what was going to happen to her. But you don't just have to rely upon The Wire. The testimony from Dr. Buxbaum and Dr. Walsh-Hanley conclusively demonstrates that Joni Gunter knew what was happening to her when this crime happened. This isn't a situation where it's a bullet in the back of the head, it all happens quickly, there's no pain, there's no torture. The bones of Joni Gunter prove, beyond and to the exclusion of every reasonable doubt, the unnecessary torture that she endured at the hands of this defendant. Using your expertise, doctor, what is the nature of the hand fractures? Tell us the manner in which they were inflicted. Well, first of all, being fractures, they indicate blunt force being applied. It's interesting, I think, that the three different fractures have different injury patterns to each one. He goes on, I think that at least two of them could be classified, at least in my opinion, as belonging to defensive category. Defensive wound is a wound that a person produces in trying to protect vital areas of his or her body from being hurt by putting up some barrier to an attacking force. So the parts of the body that are very commonly used for defense against an attacker are the upper extremities, particularly the forearm, but also the arm and the palm of the hand. Other parts of the body can also be used, such as the legs. He goes on. The basic idea is to protect the most vital areas of the body, which would be the front part of the hand or the face or the neck and the chest. So he goes on to describe the fractures. The one that's an epiphyseal fracture is interesting because I think it's analogous to what forensic pathologists sometimes encounter in child abuse cases, which is the epiphyseus, or the end of the metacarpal bone joins together with the rest of the bone. And so those are tearing type fractures, where the edge or the tip of the bone is actually being torn by force, causing the fracture. And then the other one that I haven't described yet, as a spiral fracture, indicates a rotational type of force. So the rotating force and the tearing force causing two of the three fractures, in my opinion, are fairly consistent with an abusive type wound. An individual putting up a defense to the attack would be producing a defensive wound. And that would indicate the individual being alive when doing that, being cognitive, and being aware of danger. All of these injuries are together, collectively, indicative of an assault occurring while the individual is still alive, and at least in the case of the hands, still cognitive. Dr. Heather Walsh-Haney says it a little bit more succinctly. Did you notice perimortem fractures to other parts of the body? I did. I noticed the left hand, there were fractures to the metacarpal. And there are bones that make up the back of the hand, and those fractures are consistent with a direct impact as well as a torsion or pulling or rotation of the hand. Is that consistent with a defensive wound? Yes. And trying to extract oneself perhaps from being held or moved. Would it be consistent with some type of binding on the hands and twisting, trying to get it out? Answer, I believe so, yes. And would the impact be consistent with the deceased trying to protect themselves from other injuries? Answer, yes. And that's what we refer to as a defensive wound? Answer, yes. The defendant's own words, combined with the medical evidence in this case, proves beyond and to the exclusion of every reasonable doubt that this first-degree murder was especially heinous, atrocious, and cruel. And this, ladies and gentlemen, is a very weighty aggravator because of the unnecessary torture that Joni Gunter had to endure at the hands of this defendant, and that goes to his character. That goes to his culpability for this crime. Finally, the last aggravating factor was the first-degree murder was committed in a cold, calculated, and premeditated manner. Cold is defined for you, calculated is defined for you. We talked about in jury selection, and you found in this case the defendant was guilty of premeditated murder, and the definition of premeditated is given to you. This aggravator requires more. This aggravator is a heightened level of premeditation demonstrated by a substantial period of reflection. That substantial period of reflection is up to you as jurors to decide. It's not formed in an instant. The example that we did with the Clorox wipes. That is not going to be cold, calculated, and premeditated. However, if you sit and debate over and over and over again about whether you're going to do the killing, about whether somebody else is going to do the killing, that is evidence of cold, calculated, premeditated. This was not a second decision. And remember, the defendant, in his own words, stated, well, Joni was probably going to get killed anyway. I just didn't want to do it right then. But my brother was insisting. And I didn't want to do it, and I told him no. He has a good talk game. That is the definition of heightened premeditation, this debate, this wrestling in their mind about who's going to do the killing. It's cold, calculated, and premeditated. But you can also tell by the nature of things that happened afterwards. Now, I'm not saying that is evidence of what happened before, but certainly the dismemberment and burial is evidence of premeditation before. This was not a panicked disposal. This wasn't a situation where someone acted in a fit of rage and then didn't know what to do. 5 aggravating factors: prior violent convictions, felony murder, elimination of a witness, heinous, atrocious, and cruel, and cold, calculated, and premeditated. These aggravating factors combine to make this case overwhelmingly one in which the aggravating factors are sufficient for death and that they will outweigh any mitigation that exists in the world. There is not an amount of mitigation, I submit to you, that would ever be able to overcome the heinousness of this murder combined with the defendant's prior violent record. When you combine those things, this is it. This is a death case. But the law requires each and every one of you to consider mitigation. I want to spend a little bit of time discussing that. First of all, mitigation is not, it's not a numbers game. You're going to hear, I think, approximately 59 things that the defense wants you to consider mitigation. It's up to you to decide whether it's mitigation or not. So the difference is aggravating factors are the law and have elements to them, and you have to find them beyond a reasonable doubt. The state doesn't get to tell you what the aggravating factors should be. It's what the law says that they are. Mitigating factors can be anything. And we talked about it in jury selection. I think you'll hear more about it later. But it's not a numbers game. It's not a situation where they have 59 and we have 5. Not the way it works. I want to begin by discussing the mitigators having to do with Dr. Toomer. Now, Dr. Toomer, personally, my problem with Dr. Toomer is nothing personal. He seems like a nice man, and if you had problems, he'd probably be a pretty good person to talk to about those problems. However, you have to analyze his testimony like you do any other witness. You have to analyze, is what this guy, this doctor said valid? Should I consider it at all? Is what he says reliable based on the information that he got? It's all common sense, weighing the evidence. You're going to be able to figure out pretty quickly that you should disregard what that doctor says. I'm just going to give you a couple examples. Feel free to come up with more. This man came in and gave his psychological opinion, having met and spoke to this defendant one time on Sunday after he was convicted of first-degree murder. He's able to tell you with no level of confidence, it's just his, quote, opinion, my opinion is, he didn't say, you may have noticed that when the state asked opinions of doctors like Heather Walsh-Haney or Robert Buxbaum, we said, within a reasonable degree of medical certainty, what is your opinion? We put some weight to it. That was not done. It doesn't have to be. I'm not saying it's required. But with no weight, he's able to tell you that the defendant suffers from emotional distress during the crime. He said that. That was his opinion. The defendant was suffering from extreme emotional distress during the crime. And then it was like either it was a question before or a question afterwards. The question was posed, did you ask him about the crime? Answer, no. How on earth can a psychologist render an opinion about what Mr. Tillis was feeling or doing or the stress that he was under when he didn't even bother to ask him about the incident? Only in America do we see things like this. My opinion is X. Did you ask him about X? No, I didn't ask him. He talks about the history of this defendant's horrible life and abuse. Mind you, the defendant doesn't say that. He denied it all, which I think we can understand. I'm not saying that everyone has to be forthcoming about abuse. My quarrel is that this doctor is giving the opinions of what other people say, hearsay, mind you, not from the source. I heard that somebody said that he was abused, and giving that perfect validity to make his opinion and ignoring what the defendant says, and then doesn't even bother to talk to the only other person in the world that could corroborate this, the defendant's brother. Doesn't even try. Well, I didn't talk to him. I can still give my opinion. He admitted that the more information, the better. I submit to you that the opinions that that doctor gave were nothing more than a closing argument that he wanted to convince the jury that the state is just wrong about the criminal justice system. He wasn't even answering my questions. I mean, you decide that. It's not for me to decide. Was he honest and straightforward in the questions that I asked him, or was he trying to advocate for something? You make that decision, not me. This doctor is so brilliant that the defendant telling him he did not suffer from childhood trauma is evidence that he endured childhood trauma. The definition of a catch-22, circular arguments. The doctor says that the state cherry picks information. He cherry picks what he wants to believe and doesn't believe so it can fit his narrative. The only distress that this defendant was under was whether or not he was going to have enough time to dismember Joni Gunter and cook his methamphetamine. That's it. That's the stress that he was under. Dr. Buffington. At $500 an hour, we learn that drugs are bad, okay? And they do bad things to your brain. But interesting, I submit to you, he turned into a state witness that helped show the character and the mind of that defendant. He wasn't strung out on some street corner injecting pine sol into his veins. No. He was much more cold, calculated in the way he went about doing drugs. A guy that was able to sustain his habit and produce his own drugs, and it's hard. And you know why? We heard evidence not only from the expert, but from the defendant's own son, because when he's cooking meth, he caught a place on fire. It's really complicated to do this. It's not baking a cake. It's hard and difficult work. It's evidence, I think the quote was, of a focused mind. The kind of focused mind that kidnapped, murdered, and dismembered Joni Gunter. The drug use in this case is not mitigation. It was his choice to live his lifestyle, given countless opportunities to not do drugs. He did them. You know, the uncle and the friend testified, and interestingly enough, they both said nice things about the defendant. He gave me a place to stay. He was always there. I mean, it's hard to hear the one guy, he couldn't hear. But they both said nice things about him. He was there for them. You can't have it both ways. You can't be such a damaged human being because of your upbringing and your drug use and falling off your bicycle. You can't be that damaged of a human being that somehow that mitigates the potential punishment, but at the same time be capable of all these wonderful things. Can't be both ways. Mr. Tillis may have endured trauma as everyone in the world has. And his trauma may have been worse. Mind you, the evidence of this is all hearsay. It may have been worse than average, but it's not mitigation. We heard from Ron McAndrew. And Ron McAndrew said about the ins and outs of his prison time, that during this period of time, this defendant had multiple opportunities for reform. There cannot be a better reform place to get off of drugs than to be locked up and realize your life is going down the toilet, right? It worked for his son. It works for countless others. Sometimes it doesn't work, but after 4 times, maybe it should get through that lifestyle is not good. Intervention was given to this defendant over and over. If he wanted to, he could have gotten clean anytime. He had structure. I mean, his girlfriend, I'm sure that y'all were as shocked as everyone was in this courtroom about how normal she was, and that she gave this defendant an opportunity with her family and her life, and he said, nah, I'd rather have prostitutes come to my house for meth. In the early 80s. His behavior in prison, mind you, he, in his early days, was not a good prisoner. I mean, he may have not been the worst prisoner, but he had, I think it was 1350, I forget the number. It's in evidence. And you heard the testimony of it, more importantly. That he got DRs all the time, disciplinary reports for lying, for fighting. There's some violence in there. But that's not a reason for him to get the death penalty. That's not an aggravating factor at all. But it's not mitigating either that as he got older, that he stopped doing those things because he realized that he was losing gain time every time he did it. So he stopped doing it. That's not mitigation. You know, the analogy that I would equate to the being good in prison is if you put a barking dog that won't stop barking, and it's driving you crazy. If you put that barking dog in a soundproof room and you no longer hear the barking, that's not mitigation. You're going to hear things, and there's the list of mitigators. Frankly, it's a little shocking, but you'll hear. You're to decide what they mean. I mean, it's not for me. There's a couple I want to point out. One is there's actually a mitigator listed that the defendant was good to Tabitha Nicole Hogg. He provided her a safe haven. And he encouraged her to get off of drugs. But Tabitha Nicole Hogg testified in this courtroom last week and told you how she was chained and raped. How was the play, Mrs. Lincoln? And they want to claim it as a mitigator. Another one that's similar to that is something that you'll have to make your own decision about, and that's about whether the defendant behaved appropriately in court. I mean, you saw him testify. You decide whether that was appropriate. You saw the defendant stand up and start objecting, or I don't think he stood up. I think he just started yelling, objection in the middle of court yesterday. Is that appropriate behavior in court? You decide those things. But when you see the list, those are the kind of things you're going to be presented with. And the question is not whether or not this was a fact of this defendant's life, because I submit many of the things presented have not been proven, even by the preponderance of evidence, even by that lower standard, which is the law. It's absolutely the law. But even by that, are these things mitigating circumstances? Do they reduce the culpability, the responsibility? Should they reduce the punishment for what he did? I also anticipate that you're going to hear about, and Mr. McAndrew talked about this, about that he would be secure if the verdict was life in prison. And that's true. Life is life without parole, and you will not hear us argue any differently. And while that's true, that's appropriate for many first-degree murders. It's not appropriate for this case. The process of justice is not about the future harm that could or could not happen. The example I'd like to discuss is tomorrow. I mean, the medical advances with shots and inoculations and vaccines, right? It's amazing what this country's been able to do in such a short period of time. Maybe one day scientists will figure out the shot to stop violence, the shot to stop murder, the pill to eliminate criminality. And if we had that invented and Mr. Tillis received that pill, that shot today, and it would be guaranteed that he was no longer a criminal and no longer a threat to anybody. Does that change anything that I've just been presenting? Does that change the justice for Joni Gunter? Does that change about what he did in the past? This is not about future dangerousness. This is about past punishment. That's what the criminal justice system is all about. We can't predict the future, ever. But we can make people responsible for the past. And that's the decision you have. Is life without the possibility of parole the appropriate punishment for this defendant's past? Or is the death penalty the appropriate punishment for this defendant's past? We heard from the family today as well. People that don't know the defendant. Despite being called by his first name hundreds of times, they don't really know him. You only heard from essentially a grown woman now, but a child back then, that fell for the good-looking, middle-class guy who was charming enough to convince her for a short period of time that he was a good guy. They don't know him. He's not part of their lives. And your sympathy for them, especially the son, who the state does not in any way, shape, or form believe that he doesn't want to have a relationship with this man. That's normal. That's not mitigation. It's not. It's sympathy for this kid that lived without a father. It doesn't have anything to do with this defendant. The victim impact that you heard, I want to be clear about this, the judge is going to tell you, is not evidence. It's not an aggravating factor. You can consider it as to the uniqueness of Joni Gunter and the effect on that family. It is not an aggravating factor. But certainly you learned that Joni Gunter and Ashley Gunter's life was a heck of a lot harder than this defendant's. A heck of a lot. There's actually an aggravator that lists that this defendant is a human being. That's listed as a mitigator, that he's a human being. And it's pretty obvious that we're not debating whether or not an animal should be put to sleep, because you don't have courtrooms and due process and judges and bailiffs and jurors and prosecutors and defense attorneys debating about whether or not the cow should live or die. The defendant is part of the primate species called Homo sapien. But is his life human? Do human beings rape? Do human beings kidnap? Do human beings kill, torture?
Members of the jury, remember that what the attorneys say is not evidence or your instruction on the law. You may continue.
Human beings should not kidnap, rape in the 80s, the 2000s, and all the way to 2015 when they murder. The level of aggravation in this case is overcome, and it's not mitigation that he is a member of the primate subspecies Homo sapien. It's not. The law never demands a death sentence, but the facts and common sense allow you with confidence to vote for death for the Homo sapien known as Russell Tillis. Today is April 15th. April 15th is Jackie Robinson Day in Major League Baseball. Jackie Robinson's epitaph reads, "A life is not important except in the impact it has on other lives." Judge this defendant's life by the impact it had on Maria Leone, Brescia Settle, his friends and family, and most importantly, Joni Gunter. Thank you.
Thank you, Mr. Mizrahi. Mr. Mayers? Ms. Miller?
May it please the court.
Yes, ma'am.
Russell Tillis was raped by his father. The one man put on this earth with the only duty of protecting his child, and he anally penetrated him, his own son. Mr. Mizrahi said in his opening statement in this penalty phase presentation that the mitigation was insignificant or unsubstantial. I don't remember the word he used.
But he obviously spent some time in his closing argument talking about how the mitigation, the list of mitigation that you're going to be provided, shouldn't be considered by you as mitigation. And he's correct. There are about 60 things listed. It's not comprehensive. It doesn't include any of the testimony that you heard today from Ms. Brinkley or Nathan Tillis. And you all may consider absolutely anything to you that you consider to be mitigating. But on that list of nearly 60 things that we suggest to you are mitigating includes that Russell was raped by his father. The crimes that you've heard that Russell was convicted of in 1989, in 2006, the crimes you've convicted Russell Tillis of, those things happened to them because they happened to him. Life in prison without the possibility of parole is an incredible sentence. It's huge. It's massive. It's weighty. The suit that Russell's wearing right now, today is the last day that Russell Tillis will ever wear anything other than a prison jumpsuit for the rest of his life. The question now is, will he die in prison of natural causes, or will he die when a needle is stuck in his arm and his body is pumped full of lethal chemicals until his heart stops? Your verdict has determined that Russell Tillis no longer has the right to live among us. But he does not need to die for his crimes. Russell is badly broken. He's damaged, but he's not beyond redemption. Mitigation is never offered as an excuse or justification for the crime of murder. There is no excuse or justification for the crime of murder. Mitigation can be why? How'd we get here? But please remember, it does not have to relate to the crime itself. And so you may absolutely consider that Nathan Tillis wants to have a relationship with his father, which would be difficult if he were dead. Mitigation is why any one of you would choose life or not choose death. And we heard a lot of things during the 2 days of jury selection about what everybody would like to hear in making this kind of decision, whether someone lives or dies. But I think most of you said you'd want to know everything. Mitigation is what you need to know to make the decision about whether Russell Tillis lives or dies. And can you imagine if you didn't know that Russell was raped by his father and you sentenced him to die, and some years pass and some passerby says to you, well, did you know that Russell Tillis was raped by his father?
Well, I object, that's improper.
It's
Members of the jury, remember that what the attorneys say is not evidence or your instruction on the law. You may proceed.
Thank you, sir. If it was later, if you did not know that Russell was raped and you made this decision, and it was later posed to you, did you know that Russell Tillis was raped as a child? You would think, man, I wish I would have known that when I was making that decision about what the appropriate punishment is for his crime. Russell's parents are the people who were supposed to protect him, and they failed. We as a society, the government, the state of Florida, is supposed to protect children from the things that happened to Russell from happening to Russell. We failed him. He was not protected. He was beaten. He was struck. He was abandoned. He was neglected. He was poisoned by violence. And then he began poisoning his own body with drugs and alcohol when he was a child. Alcohol, marijuana, amphetamines, methamphetamines. He started at 12 years old, 13 years old. Around the same time that Russell's mother told Russell and his brother Claude to start locking themselves in a trailer in the backyard so she could get some sleep without worrying that her husband was going to molest her children. Dr. Toomer and Dr. Buffington, I would suggest, are very smart, well-educated, well-credentialed men. And frankly, I think what they said is kind of obvious, that children need stability, security, and predictability. And without that, children can't thrive. I don't think you all needed a man with a PhD to tell you that, but that is what Dr. Toomer possesses. Human babies are, in fact, the only species of mammal that are born completely dependent upon their parents. And they continue to exist that way for, give or take 18 years. Russell's childhood was the opposite of stability and security and predictability. And the state of Florida wants to talk about Russell understanding right from wrong. Well, yeah, no one's suggesting otherwise. We talked about this in jury selection. If Russell was so mentally ill, diseased, or defected that he did not understand right from wrong, or he could not conform his behavior with the law, he would have been what we call insane at the time of the crime. It's a defense to the crime. You would have heard about it in the first part of the trial when you were deciding if he was guilty beyond a reasonable doubt of the crime. But frankly, what is the difference between right and wrong when you've been raped by your dad? What Russell is a deeply traumatized man. And I think that's well corroborated by the state's evidence. Well-adjusted, full-functioning adults don't participate in the dismemberment of a young woman and bury her in their backyard. And Dr. Toomer talked about both the things that children need, security, stability, predictability, but he also talked about risk factors that make a child perhaps more prone to violence in adulthood. And again, he didn't come in here and share rocket science. I think it's fairly obvious that risk factors include coming from a family with a history of violence, a history of being abused, drug and alcohol use. And those things don't make you unable to understand the difference between right and wrong. What Dr. Toomer said was they change your barrier, your instinct. When you want to follow that guy who cut you off and pull him out of the car and beat the crap out of him, I think was the example he used. But you don't. That barrier is gone for Russell Tillis. And you can take any one of these things that happened to Russell, and Mr. Mizrahi could pick it apart. But it's not about drug use or being abused or witnessing violence. It's about the totality of the circumstances. And beyond just the violence that was done to Russell, all he knew
was violence. And I think this is really interesting. The state spent the majority of its closing argument in the first part, in the guilt phase of this trial, saying, you can't believe a word that man says. He uses strategic perjury. He's an exaggerator. And today, we heard from Mr. Mizrahi, you can't believe Dr. Toomer because he didn't ask Russell Tillis. Well, you can't eat your cake and have it too. Right? Dr. Toomer did his job and found records and documents that corroborated what he testified to, because you can't impugn the credibility of a document. Those school records are clearly not made up. The domestic violence injunction that Margie filed against Claude is clearly not made up. And that's what the majority of the evidence about the domestic violence that Russell witnessed as a child didn't even come from Russell. It came from the injunction. It came from Timothy Pendergrass. The information about him being raped by his father, he said that to his girlfriend when he was 20 years old, and to his detriment. She left him and took their child because of it. So the state wants to suggest he has reason to lie in this courtroom. It's pretty much the opposite. He would have had reason to not tell Shannon Brinkley that in 1981. And I think the reality is, we all know that Claude Tillis, senior Russell's father, beat the crap out of Margie Tillis. And that those kids watched it every day. They were afraid to be in their own home. Timothy Pendergrass, he was difficult to hear, but I think he said one of the most impactful lines of this trial. He jumped the fence that separated his backyard from Russell's backyard to beat Russell's father with a stick to stop him from beating or attacking Margie Tillis. And keep in mind, this is all the same house. It's all same house on Bowden Circle. State, the media, they want to talk about the house of horrors. It was a house of horrors for Joni Gunter, but it started as a house of horrors in 1961 for Russell Tillis. And despite the fact that Russell's mother should have protected him, and she didn't, she picked her abusive husband over her children. Russell loved her. And the state wants to suggest that because he's damaged and broken, he somehow doesn't have the ability to be kind. No, that's just evidence of the redemption in him. Russell tried to protect his mother from his father as a child when she was ill at the end of her life. Russell had his father removed from that home, so he couldn't hurt his mom anymore. He's broken, he's damaged, but he's not beyond redemption. Ron McAndrew told us that Russell wants to be a contribution in prison, not a burden. And he can be if you sentence him to life in prison. He will work. Whether he wants to or not, he will work. If he's in a wheelchair, he will work. But he has expertise in welding and maintenance, things that will help the infrastructure in the Florida Department of Corrections. The Florida Department of Corrections relies on inmate labor for 95% of the labor within the prison facility. And I think we can all agree, Russell is not great on the outside, but he's pretty good on the inside. Since 2004, whether it was in prison or in the Duval County Jail, not a single write-up. And inmates, like Mr. McAndrew told us, get write-ups for everything. Talking back, disrespect, fighting. Not a single one. Mr. Mizrahi said in his guilt phase closing argument that he, the state of Florida, was in complete agreement with Russell Tillis that Claude Tillis is guilty of first-degree murder. I didn't say that. He did. And he also told you at the beginning of this penalty phase presentation that Mr. Tillis is worthy of the death penalty. That was the word he used. Yet Claude Tillis hasn't even been arrested. Remains free. No matter what sentence you decide. You cannot bring back Joni Gunter. You can't give her back to her grandmother, to her aunt. You can't make them whole. And because of that, Russell Tillis will pay with his life. He will never live among us as a free man, but he doesn't need to die for his crimes. Death is never required. Not in this case, not in the worst imaginable case. And if one of you believes that life should be the verdict, then life will be the verdict. And Russell Tillis, regardless of what you think of him, has the absolute right to 12 individual moral assessments about whether he lives or he dies. What is an individual moral assessment? It's a deeply personal moral decision. We make them all the time. What religion to practice, if any? Whether or not you're going to have kids, how you're going to raise them. You were diagnosed with cancer and had options, treatment, radiation, surgery. I suspect you wouldn't expect that 12 strangers you met coming into this courtroom for jury duty would weigh in on such a deeply personal moral decision. And we would never expect everybody to have the same opinions on such deeply personal moral decisions, because everyone comes with different sets of values and different life experiences. There is no such thing as a universal truth when it comes to deeply personal moral decisions. And this penalty phase proceeding is the same. Where does the decision to give life come from? It comes from mitigation. It's what any one of you assigns the weight of life to. It's why you say, I choose life, or I don't choose death. And you're going to get a list of things that are suggested as mitigators. Generally, I would say that a history of horrific abuse is mitigation. Exposure to violence as a child is mitigation. Heavy, addictive drug use to hard drugs over the course of 30, 40 years is mitigation. Brain injury is mitigation, but each of you must make this decision for yourself. There is tremendous responsibility in deciding whether someone lives or dies. And you all have to live with yourself when you leave this courtroom. You all have agreed to respect each other's opinions, even if different from your own. And interestingly, deliberate is actually defined as to carefully consider. It doesn't mean debate. You don't have to out-debate each other on your individual moral assessment or to have your individual moral assessment heard. You have the right, the duty, and the obligation to vote for life if that is your personal moral decision. In fact, we talked a lot about it in jury selection. And you all committed that if you have reached an individual moral assessment that the verdict should be life, that you have a duty to make sure that verdict is returned in this courtroom. And if it's not being respected by your fellow jurors, part of the instruction includes that you can knock on the door to the deliberation suite, ask the bailiff to get the judge, let the judge know we've reached a verdict, we're done here, and we're going home. In order to ensure that each of you comes to this individual moral assessment on your own, or that it's reflective, the verdict is reflective of your individual moral assessment, the judge is going to read you a polling instruction, or ask you a polling instruction, after the verdict is read. If the verdict is for life, the judge will ask, do you, and this is name of juror, but he'll use number of juror, agree that at least one member of the jury voted for a sentence of life imprisonment without the possibility of parole? If the verdict is for death, it would be, do you, juror number, agree that each of the findings in the verdict form is yours? Because, to steal a lovely quote from jury selection, the law puts great emphasis on life. And I also want to just briefly go over the verdict form. And the one you will get is much longer than the one I'm referring to, because it will have all of the mitigation, the possible mitigation listed. The first step, as we discussed, is, has an aggravating factor been proven beyond a reasonable doubt? All of you must agree that at least one aggravating factor has been proven unanimously beyond a reasonable doubt. If the answer to that is yes, you move on to the next step. Is that aggravator sufficient to warrant death? If the answer is yes, you move on to the next step. Have mitigating circumstances been established by the greater weight of the evidence? If the answer is yes, you move on to the next step. We, the jury, find unanimously that the aggravating factors outweigh the mitigation. Still, if the answer is yes, you move to the next step. And despite all that, if your answer is yes, 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 the last question is death the verdict for me? And it's never required. No matter how weighty the aggravation, it's never required. And sometimes these conversations, folks may want to say, these are the reasons in aggravation. You've reached a verdict for life, explain yourself. And you have the absolute right to do that. We encourage you all to consider each other's opinions, but you also have the right to say, I have reached that individual moral assessment that the verdict is going to be life, and I can't articulate it. I can't list it. I just know in my heart and my gut that I'm not imposing a death sentence today. So what am I doing here? I'm asking you for mercy. I'm asking you for mercy for that little boy who had all of those horrible things happen to him and became this man. Mercy cannot be earned. It cannot be deserved. William Shakespeare wrote about mercy in The Merchant of Venice. It twice blesses. It blesses those who give it, and it blesses those who receive it. Blessed are the merciful. End the cycle of violence. Sentence Russell Tillis to life in prison. Thank you.
Thank you, Ms. Miller. Members of the jury, as I said, the next thing that will happen is I'm going to send you to lunch and then bring you back, and I will instruct you on the law, and then you will deliberate your decision in this case. As I told you when we were nearing this stage during the guilt phase, we're close to the end, but we're not there yet. So do not begin to deliberate with each other or even in your own minds at this point. Just go to lunch. Do not discuss the case. Do not look up anything about it. Do not let anybody discuss it in your presence. and we will see you back at 1:15. 1:15. Anything we need to discuss before we recess for lunch? Okay, let's come back at 1:10, and we'll go from there. 1:10. Court's in recess till then.
quietness.